Hi, Bill Henshaw here again, Constitutional Crisis Channel. Current events, and this is the same subject we were just discussing, the nomination of Gorsuch to the Supreme Court. But a little different thread of thought here, because, you wonder, if you look at the Constitution, nowhere in there does it say that you have to go to law school, that you have to be an attorney or anything to be a federal judge, let alone a justice on the Supreme Court. So my big problem with this is, how is it that the American Bar Association has become intimately involved with this process to the point where a nominee basically needs their approval to get appointed? What the hell is this? And particularly when you realize how crooked the ABA is, and all they want to do is keep people in there that'll see things their way and not give any of us a break. And that's my whole problem with the whole issue of assistance of counsel, effective assistance of counsel, which I don't think exists, and I believe my record establishes it does not exist. So, like I say, I've got some real problems with that, and were I involved in the confirmation proceedings, I would have some questions for the members of the ABA. I just don't see how they can be involved in something like this. And by the way, take a look at the case I referenced earlier called Department of Transportation versus Association of American Railroads. 2015, the U.S. Supreme Court decided March 9, 2015, because a lot of what they say in that case could, as far as I'm concerned, apply to the ABA in this setting. How can we get people on the bench to do the jobs that are supposed to be done if they're all going to be attorneys and they're all going to be, have irreconcilable conflicts of interest against ours? That's a big deal for not only the lower federal courts, but even the Supreme Court itself, as far as being neutral arbitrators are concerned. Now, continuing discussion about the ABA and the confirmation process for justices, and it's my basic position across the board in all criminal cases, there is no right to assistance of counsel. That goes to the 14th Amendment not having been properly ratified. But if that's the case, the question then becomes, how do you go into court as a pro per litigant, not pro se? You're not acting as your own attorney. That's a difference that most of them pretend not to understand. You go in there in pro per and want to make your case, and yet you've been put through the mandatory public quote-unquote education system in which there are no meaningful and substantive protocols for the study of the Constitution, history, and laws of the United States. I didn't get it 50 years ago when I was in school, and had I been able to go back from our reunion last year, I would have gone had I not been in the South Carolina jail cell. If my history teacher would have showed up, who was also the football coach, that's the way it was in those days, I would have said, Vince, there's a few things you missed in the American history class that we had in 11th grade here. I would have said it with tongue-in-cheek, mind you, but they simply weren't teaching us even at that time, and I don't even know if my mom got much in the way of that even 30 years prior to that. They're just not teaching it. I mean, the information I've gotten hold of in the books, a lot of them contemporaneous in the 19th century, not all of which should have been in the mandatory school system, but there should have been some. The only two cases we heard about at the time from the Supreme Court, Marbury versus Madison, with which I don't agree entirely, and the infamous Dred Scott decision known as Scott v. Sanford, 19 Howard 393. And we didn't get the lowdown. If I had been taught correctly about Scott in high school, my life would have been dramatically different. Because now I know. Because, you look in there, and Roger Brooke Taney, the Chief Justice, said in there exactly that the black man has no white rights that the white man is bound to respect. But read the context he was talking about. You never get that. That's all you get for what I think is the best justice that we've ever had on the court, regular justice or Chief Justice. He made no mistakes in this case, and what it really was a discussion about the power of Congress in territories, which is vitally important today, given the fact that my record establishes there are no states. We're in territories, and maybe they think we're in the District of Columbia from coast to coast. That's a video for another day, but trust me, that's not nearly as crazy as what it may sound at first blush. But here's the problem. Again, we can't engage counsel because counsel is an officer of the court, makes a general appearance, and stipulates to the very jurisdiction we want to challenge and have a right to challenge. And yet we don't have any way to know how to do that, given the fact we never got any basic training in any of these subject matters. You might want to ask your local boards of education about that, and when it is, you might expect them to change the curriculum so you get this stuff in their schools, for crying out loud. Okay, but I'm going to follow up with more on this later, but trust me, this is the key to the whole thing. We can beat them across the board with the council issue. Thank you.